Thank you, Tom, and thank you everyone for joining us this afternoon. We're going to be tackling a really interesting topic. I think that's going to impact everyone. I'm really excited to really be moderating this conversation and talking with the experts at DPA who are joining us to discuss return on investment of construction claims. And the ROI, return of investment, is critical. It's a question, all our questions our clients are going to be asking us. How to best advise clients on legal strategy and construction claims is what we're going to hope to give you some tips and pointers on as we go through the presentation today. As Tom mentioned, we would love to field questions, so put those in the chat and we'll get through those at the end. I think we are going to reserve enough time to do that. But I'm really pleased to be here today to join Philip Roy and Marc Rosenbaum. And Marc, why don't you take us to the next slide and we'll jump in. Briefly want to give some introductions. I'm Brenda Radmacher. I'm a partner in the Los Angeles office of Gordon, Reese, Scully, Mansicani. I am the head of our construction group out of the Los Angeles office. My practice is representing contractors and design professionals in both advice and counsel work and litigation and dispute resolution of a variety of complex construction claims. And, you know, this topic is near and dear to my heart because the things that clients are looking to us to do is to help them understand not only what the claim is worth, but is it worth it to pursue it, or how much should we spend to defend it? And so these are issues that I'm excited to talk with Phil and Marc about. So I'm going to turn over. Phil, why don't you and then Marc introduce yourselves as well?
Great, thank you, Brenda. Thank you, everybody who is on today. My name is Philip Roy. I am a senior vice president with the firm of David Patil and Associates. We are also a sister company to the Soco Tech Videris family of companies. I focus solely on recovery of projects that are either in trouble or projects that need a turnaround specialist that are in various phases of a damaged environment. We also do project advisory, pre-construction efforts. So we don't have to have lawyers and folks like us on the project, which is the end game for all. But for now, we're talking about projects that are in trouble, and, you know, is the fight worth the investment? Marc?
And I'm Marc Rosenbaum. I'm a senior project manager with David Patil and Associates, and I work with Phil on both project recovery and project advisory.
And Marc, you've got the slides, I think, so we'll let you keep advancing. We've got a couple of highlights here on both David Patil and Associates, and if you're not familiar with them, feel free to reach out to Philip or Marc. And the next slide has some highlights about my firm, Gordon and Reese, and happy to answer questions offline about our firm if anyone has any. But let's not spend time about us. Let's talk about what we're here to discuss today. And really, you know, the questions, I think, how many, you know, this is good, we can have you raise your hands. How many, who's ever been asked by your client, how much is my case worth? Every one of us, right? How about how much can we expect to recover? Anybody ever been asked that question? And what we used to say, the $25,000 question, but now it's $25 million question, you know, how much will it cost? Is it going to cost me? How much is it going to cost to get there? And, you know, we do, as part of our jobs, both as lawyers, as in-house counsel, and as experts, we do our best to give an analysis, usually at the beginning and the outset of a matter, where we're looking at what are the damages. We're looking at what is this case really worth. We also are going to look at, you know, reasonably, what's the reasonable expectation of recovery or liability exposure. How much it costs, you know, oftentimes we're giving clients budgets and we do that analysis. But oftentimes I think they're segregated, where we look at entitlement, we look at damages, and we look at kind of a budget for how much it's going to cost. And so we don't necessarily marry those together. And working with and looking at what Philip and Marc have developed, an innovative analysis and decision-making tool that we're going to walk through today about some ideas of ways that we can use an evaluation of construction claims to determine the return on investment for a client, and how we can, as advisors and consultants to our clients, really give them as a more of a robust approach and an interesting opportunity of them be, maybe be more analytical. Although no one's ever said any of the lawyers are under analytical. We oftentimes be over analytical, but sometimes we don't see the forest for the trees. And so what we're going to talk through today are how can we manage the information on claims to assess return on investment. We're going to talk about case management ideas. We're going to talk about how we can utilize these tools to really make them a tool on helping a client to simplify big decisions, and particularly financial decisions, how to help with communication with clients, between the client and frankly the whole team, between the client, the consultant, and the lawyer, to have realistic expectations and enhance our client relations. So that's really kind of what we're hoping to cover today as we go through this, and we're going to drill down somewhat more specifically in some real options and ways that Philip and Marc have developed of how to approach this. So we want to start with, how are we going to go about this, and what are the issues? And we want to talk big picture of, issues that you're going to have to evaluate. And again, contract requirements. Obviously, that's one of the first things we're all looking at. What's recoverable, who's liable, what's the notice, what are the different procedures that need to be adhered to for a claim, and how we go about that. And, looking at who are the parties, how are we going to go about recovery, and what's the strategy. So Marc and Phil, maybe Phil, you can start us a little bit on how do you on your consultant side look at these issues, if at all, and what can we do to work together with counsel and consultants, and at what phase do we even start talking about these issues as part of our strategy of evaluating return on investment?
Right. Well, that was a great lead into Brenda. So the one thing I've learned over my 15 plus years in doing this is the communication side has always been somewhat of a struggle. It's everybody gets a little nervous when they say, well, what's recoverable? And how do we go about determining what's recoverable? What's the best practice in doing that? And we all kind of work in little, I would call vertical silos. The attorney says, I need a report that shows X. The subject matter experts go out and we try to figure out what that X quadrant is. And what I have found that has been very, very helpful is increasing the level of communication with counsel. So in a lot of my jobs over the last dozen years, I've really started out by engaging with counsel to find out exactly what they are looking for and what on the client side the client is expecting. So when we talk about what is recoverable, we only know what's recoverable when we start what I call peeling the onion back and understanding what the damages look like and where the damages are and who respectfully is responsible for that, which goes back to talking with the lawyers and the contract specialist on, okay, what's in the contract? What does the contract speak to? And then you peel it back even further, going into the liability side of the equation and the protocols associated with the contract, the notices, like you were saying, in the payments. So as we start to peel the onion back, the story starts to evolve. And that's where the communication really becomes dynamic in managing these cases. So one of the tools that we've developed over the past several years is really breaking that down into a communication tool that we can go back to our clients and say, here's what it's going to take, and here's what it's going to take to understand what the damages are. Not at this point understanding the dollars, but what is it we're looking for? And then what does that look like from a dollars standpoint, and really breaking it down in a systematic order so the attorneys then can look at it and go, okay, now I'm understanding what it's going to take to go to the next level of recovery, if there is recovery, because sometimes there isn't.
Yeah, I think that's a really good point you make, Phil, is the issues of, we're looking at so many different moving parts oftentimes in these cases. It's also easy for the clients to focus on just the dollars and looking at, these are the damages without first evaluating what the procedural requirements are and what those costs may be. A lot of times we talk about venue and, is our dispute going to be in arbitration and what's that going to cost versus being in court? Or do we have any pre-litigation procedures or protocols that have to go through? But with looking at, a delay claim or a defect issue, if there's a right to cure requirement. And sometimes by the time we as lawyers get these claims, sort of those things have passed, and really figuring out what steps need to be taken is something important to evaluate at the outset. Now, looking at moving to issues and identifying these issues, what are your thoughts on how do we do that up front? Because sometimes, the claims may be, if we're making the claim, we're sort of investigating as we go. So what's the approach to dealing with that?
So we'll talk specifically about the defects. It's really peeling the onion back, going back to the original set of documents that either the subcontractor or the general contractor were involved with. So this is what you're to build, and how did that process work through to where you end up in these type of cases? So it's really looking at the defects, and you can't look at it with a single optic. It's got to be very broad reaching. One defect has a trickle down effect to other ones. So what may look on the surface as being a very obvious issue, unless you peel it back and go, oh, hey, wait a minute, the cause of that defect actually wasn't that individual or subcontractor's fault. It could be 2 or 3 down the line. So it's taking a very concise, what I would call a sniper shot going. We have to be very precision in how we're looking at these defects. So part of what Marc does for me in our group is, Marc being an architect, has a very good understanding of the interpretation of the design and the documents. However, I have other people on my team who were general superintendents for 25, 30 years who look at it and go, hey, wait a minute, the means and methods may have caused this to happen and caused the delays and caused the further damage. So we really take what I call a crawl, walk, and run approach. And Marc, do you want to speak to that a little bit?
No, I'll add to that and say it's kind of a methodical approach where you outline the different issues that can vary from defects to damages related to lost time or loss of value, and you put them all out there and you evaluate them, and then you compare those to the contract requirements, and you begin to eliminate the ones that are not recoverable or maybe more risky to recover, and then you start to develop a strategy, an overall recovery strategy based on what you see in the field, what develops during that period, and then what ultimately is tied back to the contract and what's recoverable.
And again, Brenda, that's where we go back, and I have a lot of engagement with our counsel for our owners where we may be uncovering certain conditions, but if the contract doesn't afford me the avenue to navigate in that specific direction, that's where we put the brakes on. And what I call going to the balcony, looking down, going, okay, wait a minute, I've got to look at this a different way. So there was a lot of stop and go, because what we don't want to do is just run out there with a maverick approach, because that's where it gets very costly when we're managing these claims. I've sat in way too many meetings with owners, and it's, hey, my bills keep coming up. Where are we at? What are you doing? What's the next steps? So I think when we get into this presentation, you'll see that we take a pretty analytical approach to it. And like you said early on, Brenda, I haven't met too many attorneys, lawyers, subject matter experts that look there and say, here's our budget. This is what we can do it for. And here's what you're going to recover at the end. Because it's like throwing a handful of darts on the wall going, I hope I hit the right number. So what we're trying to do is not try to hit the right number. What we're trying to do is target the right number. Like, what is that right number of what we can recover? And sometimes we have to make adjustments backwards. It isn't going to be a $1.5 million recovery. It's going to be 800,000, and here's why.
And that leads to the slide that's been put up that Mark put up in talking about the responsible parties, you know, and folding in the analysis that you're talking about of what are the issues and what are the damages, who are the responsible parties, you know, are they viable? You know, in particularly in the last couple of years, we've had a lot of different challenges and successes for some, but I know there are entities that have gone out of business with COVID, even though construction has been an essential business in the last year with COVID. There's still struggles, and so there are issues to say is, you know, where's the line of money to be chasing as well, and are you going to, you know, if you have you have an entitlement but you don't have a recovery route, you know, that's something to be taken into consideration as well.
That's a really good point about COVID. Have several projects going on now throughout the United States where manpower has been a challenge, and so there are now delays on these projects, which this is a pandemic. So I think lawyers are sort of looking at it with a different set of optics now. So we understand there are delays, but we also understand there's a bigger picture. And I think that's where we're going with this is, you know, at what point does the recovery become an exhaustive measure that you can't pursue any longer?
Well, let's keep moving ahead because I really want to dig in a little bit to the details, but I know we've got some background we still need to look at of, you know, how you evaluate sort of what the different kinds of paths of recovery are. What are some considerations and things that you as consultants are going to need to know and to be looking at as part of this process?
So Mark, why don't you touch on this?
Well, to consult with the legal team, we need to get a better understanding of the paths of recovery, which you've touched on. But, you know, are those recoveries, is it based on, for defects in particular, would it be based on repairs? Would it be a monetary recovery? If it is, what are the routes for making that recovery? Is it direct cash payments from a contractor or sub? Are you dealing with bonding companies, insurance, separate subcontractor insurance programs? So we lean on the attorneys a lot to help us understand all the possible avenues and the limitations of different directions.
And then, you know, obviously then the next step, you know, once you figure out, but you got to look at the value. And I think one of the items that you all both have touched on a little bit is the value isn't just, you know, it's, you know, the damage is $100,000 and that's the value because that's what we, you know, put a number on it. What are some different considerations in looking at the value of a claim that would be important to consider, and how do we dig into some of that information, particularly early on in a case?
Well, the first thing we look at, obviously, if a problem is brought to our attention or we find something, is we look at the value of the specific problem. What's the construction cost? And we utilize industry tools such as RS means to determine that. We have experts on staff to help us with that. And we may go to local markets to find out what the typical costs are. But the other things we're looking at are, incurred costs that might result from delays or increased costs for lack of manpower, that sort of thing. There are opportunity costs involved that are related to all of these issues. Ongoing costs, specifically for damages, there may be increased maintenance. Lifespan of a structure may be shortened. And then there may be loss of value. If a client decides to sell a building at a certain point, somebody may come in and do an inspection, identify some of these issues, and that may incur a cost off in the future that it's a little bit more difficult to quantify, but it's definitely out there.
Mhm. Well, and I mean, and it really takes us sort of to the heart, and returning back to what we started at the beginning of the hour with, of, the question, what's the recovery? What's the strategy for the recovery, and is it really worth it? And having to figure out and take into consideration some of those things. And a lot of times our clients are looking to us as lawyers for the legal analysis. And what I think they're really looking to us for is a more robust, and what we can provide to our clients is a more robust analysis. And, to really take into consideration some of these other items of the ongoing costs, the opportunity costs, and the like, and to determine if it's worth the fight, is a very, to a certain extent, that's how risk averse someone is, a particular client. There's timing considerations involved. I had a claim this last year where my client had sort of in their mind decided how much they wanted to spend to pursue this recovery, but they wanted it done by the end of their fiscal year. And that was a bigger driver for them. And it was really important that we had the communication, that they helped me understand what their goal was. And so then I was able to work with my consultants and my team to say, how do we posture this claim in the most effective way? And there were some things we intentionally said, it's not worth the fight because of the timeline. And we were able to do that, but it required a lot of communication with the client, and my direct contact, had to go up the chain, and there were a lot of different people involved in this decision-making process. And it did feel a little bit sort of off the cuff at times. And so I'm hoping that you guys can help us work through, come up with some other tips and ideas of ways that we can do that in the decision matrix kind of approach.
So let's just go right to the decision matrix. We start off with, what does the contract say? Are there liquidated damages, consequential damages, design errors and omissions? Are there structural elements? Are there other component parts that are driving the magnitude of the claim? And those are things that we have to look at, because it all goes back to the relevance of the contract. If I don't have LDs, and what am I fighting for? So you've got to really take a step back and go, does it make sense to pursue this? Is this a scheduled damages claim, or is this more of a materials defect claim? Because the last thing you want to do, and unfortunately I've seen it in my career, where huge scheduling analyses get done, and at the end the attorneys turn around and say, well, this really isn't a scheduled time impact claim, this is more related to this. That really drove me to say, hey, wait a minute, we need to really look at this holistically and go, where are the damages? So Mark, do you want to walk through this example?
So what we've done is we've developed a matrix where we can lay out all of the claims and costs associated with a project and damages. And we've developed a method to take the damages, consolidate them, look at all of the stakeholders, which in this case might be the GC and maybe 2 subcontractors. And we've taken projected costs of repairs or damages and figured out what a total amount might look like. So we've looked at those damages, and those damages may include construction defects, impact operations, loss of value, increased maintenance costs. There may be others in different cases, but in this case, that's what we're looking at. And then we've got what we call a cost to recover. There are certainly legal fees. There's litigation support that would come from a firm like DPA, expert consultants that you would engage to do studies or write reports or testify. So we try to quantify all those costs as we identify the problems as early as we can so we can track this. And what we do is we look at each one on an individual basis. We break it out by stakeholder. And some stakeholders may be tied together, so it's not always that simple, but we've got a method, we think, to try and consolidate and quantify as much as possible. So what we do is we'll list out what we think potential damages might be. And then as the story unfolds and develops, we'll work with the owner and the attorney's team to look at recovery probabilities. And that may change as we get more information. It may go up or down. And then what we try and do is we try to handicap the ultimate amount, this total right here. And that's the anticipated recovery based on what we're looking at for each stakeholder. So in this case, it might be the general contractor has a stake. Maybe it's a $3.7 million stake that's handicapped 83%. That's our chance of recovery from what we think, based on the contract and based on what we see in the field, they might be liable for. And then we compound that with what a subcontractor might have. There may be things that we think we have no chance whatsoever of recovering. And there may be other things that we think we have a much higher chance of recovering. And then we look at whether or not we think the contract allows us to recover fees. That's also part of it. So what we do is we take all those things, and this is two cases where in this particular fictional case, we're looking at two problems with the precast on a project, the precast concrete. One is maybe we have welding deficiencies, and two, we have precast members that are out of plumb or cracked. And what we do is we go through a decision-making process. We first look at, okay, we've got a problem with the welding. What kind of documentation do we initially have from the design that would relate to that? And maybe that is design documents, welding standards that are part of specifications. And then we look at, okay, we've identified a problem in the field. We've got expert reports that show us that we have issues. And we've gone back through the construction process and looked at notes, emails, meeting minutes, and that sort of thing. And we identified potential reasons that that defect or deviation may have occurred. So once we come up with those possible causes, we look at, okay, we've got these causes. Who might be responsible? Who might be involved? And that may be a direct subcontractor, maybe a general contractor, or it might be other subcontractors or third parties who had part of the decision making. So we go back and we try to analyze that, and we tie that back to the matrix. Okay. And once we make those decisions, we look at the next step. At that point, we look at the probability of recovery. We start to make decisions based on whether or not it's worth it. If we think it's going to cost a certain amount to bring in consultants, or a certain amount of legal time, or a certain amount of project advisory time, at some point it starts to look like maybe it doesn't make sense to pursue. So maybe at that point we make recommendations to our client that they shift the strategy and pursue, invest their dollars in this in areas that might have a higher likelihood of recovery. So, this analysis, I think, works. It works both ways. It works from the owner perspective, and it can work from the contractor perspective. And I think it can work from the plaintiff's perspective or the defendant's perspective. And I'll let Brenda kind of.
Yeah, well, I think one of the questions the example you just used was showing, the owner evaluating its claim and how much, where areas it's going to pursue. And, looking at it, I can definitely see how I could implement something like your spreadsheets on the response side if my contractor client is responding to these claims and evaluating And, getting, if we're in this situation of defects, you've got a couple of defect issues and really running a similar probability of what's their recovery from their downstream trades or from the designers, or, even evaluating, and you didn't have it in the owner side, but looking at, are these issues actually because of changes from the owner or changes in conditions? And having those as line items in that analysis and looking at the recovery, and the probability of that recovery or the defense and what defenses are available. Similarly, looking at that for the contract terms, same type of an issue as, with notice, was notice appropriate, and their right to cure and those types of things, and looking at what do we think the potential is early on in a case for a trier of fact or decision maker who would, make some of those some even including some of the legal issues in with the technical. I think oftentimes in the contractor side, those are separated out, and so putting it together in one document and combining the analysis is actually, a very interesting approach. Phil, what are the other comments from the contractor side?
Yeah, I think one of the things that we don't have on here, but everybody does it, is making that decision tree, the logic ties. And the majority of the cases that I work on behalf of our clients, it's mapping out that logic tie. And it's every decision we make has to have some level of impact on the recovery strategy. And in some cases, like you said, Brenda, I mean, we may be running down a path, and because of the discovery of the contemporaneous documents that we all go funneling through, it doesn't tie together. And that's the part that I feel that we have the real obligation on, is really, bringing the truth serum to the equation. And there are no make-up stories here. It has to be defendable, it has to be factual, and it has to be backed up every step of the way. And that's the challenge that all of us on the third party side, that's really what we have to focus on, is what I am uncovering recoverable, is what I am uncovering from a damages side and a non-conformance side. Where is it? What's the origins of it? We've really got to get back to what are the origins of the impact. And I have a case I'm working up in the Northeast right now where there isn't one single entity involved in the impact. It runs a course of 5 or 6 people. And in some cases, the owner, because the owner has culpability and some responsibility in it. So it's a very sensitive approach when we're dealing with these claims, these damages, and how we look at it, and exposing like all of it, not just the one story, the side of the story that helps us. It has to be the story that says it all, and then you figure out what you're going to pursue. And with the owners, their struggle is how much more do I keep investing to get to the end game? And is the end game worth the fight? And that's what this is all about. It's factual material that the owners can make a decision on. Well, if I only have a 40% recoverable probability on this, I'm not quite sure I want to invest any more of my time, your time, and the lawyer's time in pursuing it. I'd rather go down this path of recovery because my levels of probability of recovery are a lot stronger. Not that the other ones didn't have merit, it's where do they want to invest their time and money.
Phil, this is Tom Dunn. If you could just go back to that last slide there, Mark, that we were just looking at. If you could just give us some input on how you work with your clients on this spreadsheet analysis for the kind of the loss of value, the impact of operations, what sort of, right now in this example, it's all zeros, but can imagine
Right.
those are pretty substantial
They can be.
considerations sometimes. And then there's one question from James Hamilton that I want to convey to you and Mark. The question is, are there recommended techniques, processes for valuing reduction of expected life cycle span of the project, arguably due to the cumulative impacts of the defects, or is that type of damage element irrelevant?
Well, I would not say it's not irrelevant. I think they're all relevant. It's really going with owners. I have owners who are multifamily operators. Some are on the collegiate university side. It's that valuation of everything. It's, what is it worth today? What is it going to be worth 10 years from now? We have to run through that process. And that's the part that the ownership group looks to us and says, well, what is it worth? What are the, what's my life cycle on this if I don't do anything with it? And if I do something with it, what does that cost? So again, this spreadsheet is at 60,000 feet. When we really dive into the process, when I'm looking at a damage scenario of replacing 350 windows on a particular project, it's, what are all of the trickle down impacts to that? And it's understanding the real dynamic of the makeup of what that causation is and the damages, and then what the long-term effects are going to be of it.
I think the other question I have about using a tool like this is, how have you used it effectively, taking into consideration that, this is, as you've described, sounds a little bit of a work in progress. And how do we protect that from discovery if the litigation down the road? And what tools have you used to see that effectively used?
So it's a live document. So it changes, weekly. It can change daily when we uncover another source of impact, or we come to a determination that, hey, guess what? It wasn't this particular subcontractor's cause that caused all this damage. It's over here. So the document gets changed and modified and updated as the issues either get resolved or they evolve and mushroom into either a bigger causation or not. So you're right. We have weekly calls with all of our clients on, hey, here's where we're at. The budget isn't changing, or the damages analysis has changed, and it's changed for these reasons. And we give them the tools to be able to make those decisions. Like, hey, listen, we need to do 3 more analysis steps in determining the geotech conditions on this one project that I have. It's changed a dozen times because the condition has changed. We've uncovered various impacts. So the client now understands, okay, I see how important this is. You need to keep me updated as things evolve. I've been involved too many times where you can go 3, 4, 5 weeks and the client gets an update and they're like, how did we rack up all of these costs? Well, we were doing all of these tests or analyses. It's the communication. It always goes back to communicating where we are in the process of determining causation.
I think it does 2 things. It's a case management tool, so we get all the issues in one place where we can track them, but it also allows us to track, like Phil said, some issues may evolve and get bigger, and some may run to a natural end and go to 0, and they stay on here, but we don't pursue those anymore. So it becomes a case management tool in that regard.
Yeah, I can see from council side where it would be something that I'd probably want to manage from privilege perspectives is, putting in percentage of of potential recovery, having that out there in your files would be something that would be of a concern, that, you know, how do we maintain that information being privileged? But I think the ideas are, you know, putting it together as a tool and a communication tool. You may have to be very careful and cautious as how you implement that and who's involved in that communication at what level, because it could also very readily, you know, be misinterpreted because, hey, I put a 50% recovery in there. What does that really mean? And so there's, you know, always room for interpretation. But I think, like you said, Mark, you know, from a communication tool, putting things in front, particularly if you have the clients that are extremely focused on the financials, helping them to see where the money is being spent. I think, Philip, you said it, hit it right on, where when you're having to do investigation, and this slide doesn't show it as much, but I know you had another one where you showed, you know, what the investigation steps are going to be in order to evaluate the claims. So, you know, what are the possible causes and what are we going to need to actually do to investigate this? And what is that cost going to be? Is actually, I think a lot of times we just, you know, the clients get, you know, our consultants budgets X dollars and maybe there's a few line items in it, but it's not necessarily tied as much to these steps. How do you communicate these next steps and these options for the projected cost, and how has that been utilized in your experience in an effective way to help clients as well as the lawyers understand, you know, where the dollars are going to go and how that weights into the recovery analysis?
So we really go through, I mean, it's a rather simple process. It's getting a checklist of pulling our subject matter experts together to say, okay, if I want to understand why I have settlement on a particular elevation of our structure, you know, do I do borings? Do I do soil testing? Do I do scanning? You know, what should I do? Right? We talk about it as a group, and then those are presented to our owners saying, okay, from the next step, the crawl, walk, and run is, I think the crawling right now is, let's go ahead and do some borings over in these sections. The walking is, let's get the analysis and let's look at it. And if it says that we should go to the next step, then we go ahead and do that. We don't run right to the last step and go, well, let's just tear it all down and redo it. It's, let's figure out, you know, where the next steps are going to be and what the cost factors are on that, because everybody gets impacted on this.
So I think what takes us towards our end, we're almost ready for questions. So if you've got questions, start getting them in the chat box. But I did want to ask a little bit, Mark and Phil, can you talk us through, you talked that it's a living document, that you update it and you use this as a great communication tool. What about case management? How are we using this as a case management tool? And what can the lawyers do with it?
Well, I think we use it, and we work with the attorneys to use it for case management. And we're basically, we have all of the known issues on there, all the known players, and it essentially works as a matrix. So we can see the ties, we can see the logic ties between the issues and different players, and multiple issues and multiple players. It allows us to hone in our pursuit on the correct stakeholder, if that makes sense. But also allows us to manage each of the issues and run each of them to a logical end without losing them. I think sometimes it's easy to get focused on one or two major issues, and you forget about, you know, maybe 5, 6, a dozen tiny issues that may add up, that maybe don't take a lot of investment to pursue, but are worthwhile when you look at them as a whole. So I think, you know, in that regard, it's a way to track the issues through the process.
You know, so nothing gets kind of slips through the cracks or gets lost. Right?
As the case and the project evolve, I think, you know, our focus and attention shifts. So it manages that.
Well, great. I look at it and I say, you know, one of the things that we're all asking as consultants, as as outside counsel is how can we, be more effective for our clients? How can we help them? How can we set ourselves apart and stand out? And, looking at the claims in a very analytical fashion, similar to what you've identified and demonstrated here, really does seem to be a fantastic tool to consider. I think I saw a couple of questions in the chat. There are a couple of questions we probably should look to, but I think one of the concerns is the confidentiality of it and discovery obligations of having to save the different iterations. If you're doing it, if this is a living document, how do you share this information, assuming you've been designated as an expert in the litigation that follows? Have you had any issues with this yet?
No, we haven't had any issues because I think if you're transparent throughout the process with all the parties, then it becomes an actual tool that everybody can benefit from. I think we're successful is if you are transparent, if you are bringing the affected subcontractors into the equation to say, here's the issues we're finding, and work in a collaborative environment to say, help us find out what the causations are. It's a tool that becomes, it can become interactive. I have another case I'm working on in the Midwest where we're using it as a tool to say, here's what we're finding. If we're wrong, help us understand that. And if we're right, then help us in the process of what I call peeling back the onion. That's the benefit in this, is that if the parties in a collaborative approach can look at these issues, then it avoids the elongation of litigation expense, third-party expert expense. So if the parties can come together in a more collaborative manner, then we can take a tool like this and say, okay, we know what the issue is. So how do we get it resolved? Because at the end of the day, I think everybody, when the tentacles are put out there, I think everybody wants to get settlement. Everybody wants to get it settled. It's finding that path to get it settled. And this is a tool that you can use in a collaborative environment to say, okay, here's what it is. Here's what we're finding. If the needle needs to be pushed over in another direction, educate us on where that needle needs to be pushed. And then that's where that path goes. So it's sort of like breaking down the walls. But strictly from our side, we look at it as a tool for our clients to go, okay, it makes sense, continue down that path, or we're not getting the results that I thought we were going to get. And that comes from our side as well. If we aren't getting the results, it's not like we keep digging and digging and digging till we hit rock bottom. We go, okay, well, we've exhausted every step of the way. There comes a point where you have to go, is the pursuit, like we talked about, is it worth the fight?
There was another question that was raised in the chat that I thought maybe either of you could answer, of what methods are you using to value the damages? Maybe you can talk a little bit, how do you value those damages?
Yeah, so I think Mark touched on a little bit. We use RS means. In certain cases, we will go out directly to the trades, to the trade market, and get pricing. That's somewhat difficult when you're deep in a litigious environment. A lot of subs don't want to get involved. They run from these type of conditions. But listen, we're a company of globally 9,000 employees, 5,000 being engineers that deal with this on a daily basis. So we have a very deep bench of of resources to tap into. And as I mentioned before, a good portion of our team comes from the actual general construction side. So we're living in the environment. So if we have to put a number on a recovery or damages portion of the scope, we have a pretty good barometer reading of what it's going to cost to either get the repair put in place or remediate what's there.
Tom and or Joe, do we have any other questions in the chat? And other than that, I think we are close.
Yeah, I didn't have any other questions in the chat. I was curious, Philip, at the beginning of the program, you discussed mediation. Have you used this tool or some aspect of this tool for the benefit of the mediator? I could see it being a very handy mechanism for the mediator to understand, one, where your client's coming from, but also effectively organize and prepare for the mediation. Has that been something you've experienced?
Well, on the preparatory side, we use it obviously to value what the damages are for the attorneys and for ourselves. I have not been the mediators always ask the same question. How did you value the damages? And I think I just explained some of the process to you. But I do walk them through the logic process of here's how we go through the process of figuring out why the roof is leaking, or why the facade is leaking, or why the interior of a structure, the concrete slab, is heaving. We walk them through that process of here's how we do it. You know, here's the logic ties that we use to make the valuations. So I've never received any feedback from mediators, but I think they appreciate the fact that we go through a pretty exhaustive means in determining causation and then the impact of that causation and cost.
Yeah, Tom, I think you make a great point where, as far as the issue I raised of confidentiality and protecting that information through the litigation process, if it is, and you've engaged consultants and or counsel to help conduct this ROI analysis as part of, you're doing a damage analysis, and it can be prepared for mediation purposes. In most jurisdictions, you can maintain the privilege. It's going to depend on where you are. It's a really good point. See, I think there's a couple other comments in the chat. I see Nancy Greenwald said, as a mediator, because right on this topic, this is the kind of analysis she asks the parties to go through, and including, the cost just to continue through the litigation process, lost opportunity cost, and it's a lot of things that she indicates that a lot of parties overlook. So this is a fantastic thank you from the mediator side. This is something that mediators would think would be very effective to help prepare parties for the mediation process. And a lot of clients maybe don't go through those steps. So this is a good feedback on that. Another question I see is, has this process been used or found to be valuable as part of a formal early neutral evaluation process? I don't know, Mark or Philip, if you've had this kind of tool used in early neutral evaluation.
Yeah, so I'll touch on that, and I think I spoke to it just a minute ago. Anytime there's an opportunity to have business people sit around a table to understand what the issues are, and bringing them up to speed on what the issues are and how we're valuing the impact of it, I think it's always a good thing, and we have used it when you can sit down and put it up on a screen and say, listen, here's what we're seeing. I mean, it's either real or it's not real, and if it's not real, I've sat in plenty of meeting where they say, well, that wasn't me, that was this guy. then it becomes a communicative tool. And it's doing nothing more than just putting, pencil to paper, old terminology, so you see how old I am. It's putting it out there, because that's, I think, the end game is if you can get things settled on early, then that's the objective. It's when the communication stops is when, the wheels come off the cart.
Fantastic. Well, I think we've covered all of the questions. We are about running short on our time. We want to make sure that we keep everyone. We want to respect your time. Division 1 for the litigation dispute resolution section, we're really happy to come up with really unique and opportunities to share different ideas and tools. If you are new to the ABA Forum on Construction or have not yet joined Division 1, please join us. We have all sorts of great presentations and meetings and discussions on topics like this. Thank you everyone so much for attending. If you have any questions, feel free to reach out to myself or to Philip and Mark. And thank you again. Everyone have a great rest of your afternoon.
Thank you.
Thank you all. Good day.
Thanks everybody.